Introduce yourself to everyone, who you are, your background, and why you're relevant to a conversation regarding family courts and parental rights.
My name is Don Hubin. I am a now retired professor of philosophy at The Ohio State University and the founding director emeritus of the Ohio State University Center for Ethics and Human Values. I've taught at the Ohio State University for my entire career, mostly focusing on ethics, political philosophy, and philosophy of law. I got involved in issues concerning court reform in the 90s when I went through a divorce myself. I saw the need for reforming the system even back then. I actually was one of the lucky ones. I had shared parenting of my children, but I had to fight for it, and I didn't think I should have had to fight for it. Um, and I never went through the sorts of tragic stories you hear about parental alienation and movaways and things like that. But I was made aware of the problems in the court system and became committed to trying to change those. I did some professional work on this. I've written a number of papers on parental rights and the basis of parental responsibilities as well, and published those mostly in law reviews, but in some philosophical journals as well. And I became involved as an activist, working with an Ohio-based organization for a while, and then starting up a chapter of what's now National Parents Organization in Ohio back around 2011 or so, I think it was. I joined the board, the National Board of National Parents Organization in 2014, I believe, and became the chair of the national board in 2019. I describe National Parents Organization as being child focused and research based, and probably because of my academic background, I'm very concerned that we base our policies about divorce and custody on the best research we have about child well being.
I'm Brian Vandiver. I'm an attorney in Arkansas. I've been practicing for 25 years. I practice primarily in corporate and employment law. I've taught many times as an adjunct professor at the law school in Little Rock, and I've been appointed multiple times as a special justice to the Arkansas Supreme Court. Like Don, I went through a divorce and was exposed to the family courts in Arkansas in that process, and I had to fight for joint custody myself. And so I was made aware of the hurdles for parents, particularly fathers, in the system, and became involved through that experience. Our organization in Arkansas is called Arkansas Advocates for Parental Equality, and we were instrumental in helping to architect, draft, and pass what we call Act 604, which is the presumption of joint custody in Arkansas.
Can you give some background of why you felt the system needed to be changed?
The current system in which courts will default to a presumption of sole custody if both parents don't come in and agree on joint custody or shared parenting arrangement really sets up the basis for conflict between the parents. You often hear judges and attorneys complain about how the parents are fighting and they can't get along, and they completely ignore the features of the system that encourage that fighting. I sometimes feel like, well, we've set up the Hunger Games and then we complain that the people are fighting in this. I mean, when you make someone's continued relationship with their children, for most people, the most important relationship they have in life, when you put that on the line and make it a winner-loser sort of situation, you're going to have parents fight, and it's going to increase conflict. And in some cases, some parents are going to become violent, which is horrible. So the really the reforms we need to make in the family law system are the reforms that tone down the conflict, that say, look, if you're both good loving parents, you're going to continue to be fully involved in your children's lives. You're not going to become a stranger or a visitor or a weekend parent to your children. So now go forth and figure out how you're going to work out equal shared parenting for your family, given the ages of your children, given your work schedules and things like that, instead of, getting in the court system and this adversarial system and being forced to try to show why you're the better parent and why the other parents have every bad thing about the other parent so that you can win this battle. So we need to turn the whole custody determination away from a battle, assure parents and assure children from the outset that the separation of the parents doesn't mean that the children are going to be deprived of one of their parents' full involvement.
Yeah, I agree with that, Don, completely. As Don said, the default system sets up this winner take all um, game that the parents have to fight each other from the outset to prove who is the best parent, and that's the lawyers enable that once they get involved, because the more fighting that there is, the more fees they generate, and that's part of the system. So, I experienced that in the sense of feeling like I had to prove I was better rather than just a default that, hey, both parents to this point have been fit and have been good parents, and there's no need to prove who's better. They're both adequate and good. And that should be the starting point, unless there's evidence that a parent is not fit. And that's what the law should require. So that's what I set out to try to do, and what we did do in Arkansas, to say, look, you're not going to start from zero and have to prove who's better. We're going to start from an equal playing field. And then if there's evidence that someone's not fit, not a good parent, then bring that to the court.
The best interest of the child, though, that's been on the books for decades. So why isn't that working?
The problem with the best interest of the child standard is that it doesn't create any kind of convergence of court decisions. Of course, we all want the best interest of the child to prevail. Everyone thinks that's true. But one judge or magistrate may think it's in the best interest of the child to have just one parent and the other parent be a weekend parent. Another judge may think in the very same sort of case, the very same fact pattern, may think it's best for the children to have both parents. Both of those judges are doing what they think is in the best interest of the child. And what we need is to guide their judgments. And based on the now more than 40 years of research we have that shows consistently, as consistently as any research in social science ever shows, that when parents are living apart, if they're raised in an equal shared parenting arrangement, they do just about as well as children raised in an intact marriage. And they do much better than children raised in a sole custody arrangement. If that's what the evidence shows, and it does, then we need to start with that presumption and have a reason to move away from that presumption.
Yeah, I agree with that, Don. I think the problem, as Don said, is that the best interest of the child is so nebulous. It can mean a lot of different things to different people and different judges, depending upon which judge you're assigned, and in which state you're located. And what the presumptions do is kind of establish some guardrails. I know in Arkansas, what we did in our code is we actually redefined what best interest of the child means, so that best interest of the child now is defined by the presumption, and it is presumed that joint custody is in the best interest of the child, and there must be clear and convincing evidence put forward to the court to deviate from that presumption. And so in that statutory language, we really reset the table as far as what best interest of the child means in Arkansas.
So, Brian, thank you. The thing I think would be helpful to add for Ohio viewers is this, that as I understand it, and correct me if I'm wrong, in Arkansas, joint custody already presumes substantially equal parenting time. And so when you say joint custody, you don't just mean joint legal custody. In Ohio, often they talk about shared parenting as being shared legal custody, and then it can mean any amount of physical custody or parenting time. So when you talk about a presumption of joint custody, you don't just mean joint legal custody or joint decision-making responsibility. You mean substantially equal sharing of the parenting time.
That's correct, Don. And that change in the code dates back to 2013, I believe, when Arkansas took its first bite at joint physical custody, and we adopted language that said joint physical custody is favored. And the definition of joint custody was added to our code that said that means equal or approximately equal amount of time, which has been interpreted to 50% or close to 50%, as agreed upon by the parties or determined by the court. So you're right. That definition has been in our code for many years, and the presumption passed in 2021 just built upon that definition.
Yeah.
So, can you just briefly address opponents who would say that an equal presumption puts children at risk because it presumes parents are fit? Because there's multiple arguments for why that wouldn't be, but I'd be curious what your take is on that.
So we sometimes hear that presumptions of equal shared parenting put children at risk. We never see evidence of that presented. If a parent is a risk to the children, then that parent having the child even 25% of the time, even every other weekend, unsupervised, is a problem. And if that parent is a safe parent, there's no reason why that parent shouldn't have the child 50% of the time. So it's an odd argument to say this, and especially odd in Ohio because by state law, every county court has to have a local parenting time rule. And we've studied those parenting time rules, and most of them are every other weekend and one evening a week. So there is a presumption in every court in Ohio that both parents will have at least that every other weekend, one evening a week, half the holidays, extended time in the summer, and so forth. So it's not the presumption that fit parents will have 50% of the parenting time that's dangerous. It's courts not making accurate determinations of who is a dangerous parent. Now, what we found by looking at the data from Kentucky, which was the first state to pass an explicit equal shared parenting presumption, which they passed for temporary orders during the pendency of the trial in 2017 and for final orders in 2018. What we found is that their rate of child maltreatment has gone down by more than 30% at a time when Ohio's rate of child maltreatment went down, I think it was about 3 or 4%. So this is just two states, and someone can say we need more evidence. And, as an academic, I think we always need more evidence. That's great. But the evidence we have on child maltreatment indicates that presumptions of shared parenting actually reduce child maltreatment. And since we're speaking mostly to an Ohio audience here, we have evidence from within Ohio. Because although most counties in Ohio have the every other weekend parenting rule, there are a number of counties, an increasing number of counties actually, that have presumptions of equal shared parenting. So what we did was to look at the rate of child maltreatment in those counties that had presumptions of equal parenting, those handful, about 6 or 7 counties that have that, and compared those to the statewide average of maltreatment and to the counties that had every other weekend and one evening a week schedules that they used as the default for parents. And again, what we found, similar to the contrast between Ohio overall as a state and Kentucky, was that the rates of child maltreatment were going down and they were significantly lower in the counties that had presumptions of equal parenting time. We don't know what the reasons for this are. It could be that because the parents are sharing in the parental responsibility, one parent doesn't feel overburdened and stressed, and they might take that stress out on the child. It could also be that having both parents fully involved means that if there is some child maltreatment, it'll be caught earlier and won't, lead to any serious thing that has to be reported. It could also be that by lowering the conflict between the two parents, you reduce a kind of spillover, anger or hostility that might affect, because we don't know what the reasons are. But we have no instance of any jurisdiction where a presumption of equal shared parenting has been followed by an increase in child maltreatment. And we have evidence of cases where it's been followed by a decrease in child maltreatment, including in Arkansas. It wasn't as dramatic as in Kentucky, but Arkansas passed its law in 2021, as Brian reported here, and we're starting to get data there. And consistently, we're finding that presumptions of equal shared parenting are not part of the problem. They're part of the solution for child maltreatment.
Yeah, that's right, Don. And in anticipation of today's call, I actually did a new FOIA request to our administrative office of the courts and got new data. So this is breaking news for you, Elizabeth. Based upon the 2025 statistics in Arkansas, in domestic relation cases, the fewest cases for order of protection in the past 8 years was last year. The fewest divorces in Arkansas was recorded last year in the past 8 years. And the shift in paternity cases from cases seeking support to cases not seeking support is dramatic. And we see a sharp decrease in paternity cases seeking support and a sharp increase in those not seeking support. So I think we can conclude that those are fathers and even paternity cases by mothers not seeking support because they're sharing joint custody. So I think all of that is just reinforcing what Don said, that the statistics are showing the opposite of what the naysayers are saying. I would also point out that from a constitutional law standpoint, the Constitution presumes that parents are fit parents from a due process standpoint. And so it's consistent in law to say that parents are fit, and we're going to presume that until the evidence shows otherwise. And then I would also say that in Arkansas, we have already built in an exception for domestic abuse cases. And so where you have that domestic violence situation and the evidence shows that, then that parent can bring that evidence forward and be exempted from the presumption of joint custody. So all of that's in place and all of that is working very well.
Great. So in Ohio, and Don kind of touched on this, but I want you to kind of contrast that to Arkansas. So here, our local courts have to create their own parenting time schedule. So every county essentially is doing something different. So one of the arguments is we don't need a presumption. We just need to tell courts not to have a standard and to adjudicate every single case on an individual basis and do what is best for each individual child. Can you kind of explain why that isn't necessarily a good approach?
In the first place, presumptions are good because presumptions create in parents and children old enough to understand this reassurances. So it's good to say, it's good not to say, oh, we don't have any idea what's going to happen in your case. Now fight it out and we'll figure it out. It's much better to say, look, if both parents are fit, if there's no evidence of abuse, of neglect, maltreatment, and so forth, you're both going to continue to be fully involved. That lowers the conflict between the parents. The reason the state legislature passed this requirement that each county have a local parenting time rule was to signal to parents what the likely outcome is, and then it can reduce the litigation. If you know that if there's nothing special going on in your case, this is going to be the outcome, that can speed you to a resolution. The problem is we have the wrong presumptions in most of our counties, and the presumptions are not ones that benefit children maximally. I think the reason that that some legislators might want to remove the requirement that courts have a local parenting time rule is that then we won't have any idea what the courts are doing, because now at least we can tell which courts are favoring shared parenting and which aren't by looking at their parenting time rules. The parenting time rules are directly under the control of the court. If they believe that it's best for children to have equal parenting time with both of the parents, in most cases, that will be their local parenting time rule. And if they don't believe that, if they believe that it's best for children to marginalize one of the parents, to make them a weekend parent to their children, then that'll be their rule. If you take away the requirement they have rules, they can say, oh yeah, we're ordering shared parenting all the time, and they won't have to show that they are doing that. The courts have also, the judges and magistrates have also resisted any sort of accountability and reporting of the custody decisions that they make. We've urged that they have sort of annual reports of how frequently they're awarding equal shared parenting in different divisions of time, and they've resisted that. They say that it would be too onerous to do that, but one might speculate that there are other reasons that they don't want to show their work as well. And I think really taking out the requirement that there be local rules is not going to reduce the amount of conflict between parents. It's going to mean it's wide open. No one knows what's going to happen. Um,
So, Brian, I'll throw that to you then. So, I know Ohio is unique in that way, but the idea that maybe we shouldn't have a presumption at all. What are your thoughts, and why do you think a presumption would be, if that's how you feel, would be important?
Well, I think it's clear from the states that have adopted a presumption, particularly Kentucky and Arkansas, who are the leaders, and we've seen the statistics from those states. Um, we've seen the results. I've seen the results on the ground here in Arkansas, and by all accounts, from the lawyers, the parties, and even the judges I've talked to since the passage of Act 604 in Arkansas, it's been an overwhelming success. Even judges and lawyers who were opposed to it at the time now tell me I was wrong and it's working. And I can't count how many lawyers and judges I've talked to that have told me that in private. And it's working because it reduces conflict. It streamlines the cases and really focuses the court's docket on the cases that need to be litigated. And the rest of the cases are resolved as they should be. So it's working here in Arkansas. We've seen a reduction in litigation, and by all accounts, it is a success. This is a 80-20 or even a 90-10 issue in every state, as Don will tell you. And it's favored heavily by the public. The only opponents to a presumption are the judges, particularly the family law judges, and the family law lawyers, and some domestic violence groups. And that's it. That's it. Those are the opponents. And they oppose the presumption because it threatens their power, their role in the system, and their opportunity to earn money. And that's the bottom line.
So I want to underscore something that Brian said. We have done polling, commissioned independent polling in more than 30 states now. And as Brian reported, the support, not just for the practice of shared parenting, but for a legal presumption of shared parenting is always upwards of 80% in every state. What's interesting about this is that this cuts across every demographic divide. We are a highly polarized country right now, but this is supported by Democrats and Republicans. It's supported regardless of who you voted for in the last presidential election. It's supported regardless of religion, race, ethnicity, educational level, income level, and importantly, it's supported regardless of an individual's gender. And one of the things I found, and I haven't gone back yet to check to see if this is consistently true in all of the 30 some states that we polled, but I've been looking at it in recent states, there's actually stronger support for a legal presumption of shared parenting among women than among men. It's not a huge difference. It's like 4 percentage points, 4 percentage points, something like that. But this is not a men's versus women's issue, a dad's versus mom's issue. This is parents know that it's best for kids to keep both parents involved. It's the legal system that's dragging its feet on recognizing that and enacting presumptions that will really promote that.
Great. I should have asked this in the beginning, but for people who have no idea, and I've actually run across a few legislators recently who had no idea what a presumption was, let alone a rebuttable presumption. Can it doesn't matter which one of you kind of what is a presumption, and then a rebuttable presumption, and then but Brian, I want you to answer what is an example of your state's presumption, because I think that is the gold star in language.
I think Brian should answer all of
All
this.
right, there you go, Brian.
Here, let's have a lawyer do it.
Yeah, so in the law, you can have statutory legal presumptions, and those presumptions require the court and the parties to start at some point. It presumes a fact or a legal principle that will apply to the case. And the statutory presumption in the cases we're talking about is joint custody. And so what it does is it mandates the courts start at a certain point of joint custody and then accept evidence as to whether or not that should not apply, that presumption should be rebutted in this case. And parties are welcome to put on evidence to rebut the presumption to show why it should not apply. And then the judge can take that evidence into account and make a ruling as to whether or not the presumption has been rebutted, and the judge can deviate from the presumption. And in all the states but Arkansas, the burden of proof in overcoming the presumption is just the preponderance of evidence, just the standard civil evidentiary burden that you have in custody cases now and other civil cases. It's 50% plus one. And so when you weigh the evidence, as my evidence professors taught in law school, it's if you have a tie in the evidence and a feather falls one way or the other, that's a preponderance of the evidence. What we did in Arkansas is we adopted and mandated a different burden of proof called clear and convincing evidence. And that's somewhere between preponderance and what the criminal courts use as beyond reasonable doubt. And it has to be evidence that would change your conviction, would somehow convict you that that this is not the right result. And so it's a higher burden of proof, and it's a burden of proof used when you're protecting certain rights, particularly constitutional rights like due process and parental rights. It's the same burden of proof used when states try to terminate parental rights in those types of cases. And so we built that into our presumption and passed it. And I was one of the architects and scriveners, particularly on that language, because it meant a lot to me to change the burden of proof. I knew how much of a lift that would be and how much it would upset the apple cart to do that. And it was absolutely the line in the sand, the one that the judges and the opponents wanted us to cave on, and we didn't. We held the line, and I'm proud of our legislators in Arkansas that did that and passed that statute. But it really was an accomplishment. I think it sets the tone for what can be done and what should be done, and hopefully a lot of the other states will adopt that burden as well, because it further protects the rights of parents and the rights of children to have those relationships with their parents. And so the gold standard is that it's in Arkansas, you have a presumption of joint custody that will apply, and that will only the judge will only deviate from that if the parents agree, or there's clear and convincing evidence why one of the parents is not entitled to joint custody, not fit, or one of the other exceptions apply, like what we talked about with domestic abuse or sexual predators, things of that nature.
So Brian and his colleagues are to be complimented and admired for getting the standard of evidence to be clear and convincing, because that is the proper standard for reasons that Brian was suggesting. I mean, we have now more than 100 years of Supreme Court decisions that say that parental rights are fundamental constitutional rights, and that means they can only be interfered with if the state shows that it has a compelling state interest, and there's no less constitutionally offensive way to achieve that compelling state interest. Now, of course, the state does have a compelling state interest in protecting children from harm. That's acknowledged. That's why we have child abuse laws and so forth. They do have that state interest, but the presumption needs to be that parents are fit, and they are the decision makers with respect to their children. They are the proper people to rear their children, unless the state can show by clear and convincing evidence that that's not correct. Sometimes opponents of presumptions of shared parenting look at presumption and they will add words like, this requires the courts to automatically award shared parenting, or it mandates shared parenting, and nothing could be further from the truth. The judges will still have discretion. No statute is going to say there's no discretion, and even in a case of abuse, a judge can't protect the children from that. There's going to be discretion. The presumption is the best way to think about it, I think, is just it's a starting point. I think this is the way Brian was talking about. The courts start there, and they have to have a reason to move away from that. The presumption that everyone's familiar with, if you watched any TV law shows, is, of course, the presumption of innocence in criminal law. And that is the strongest presumption. That requires proof beyond a reasonable doubt, right? The highest standard for overcoming that presumption. And yet somehow the state manages to convict people of crimes, even though there's a very strong, very high bar to overcoming the presumption of innocence. And the idea that somehow a presumption that both parents should be equally involved in raising their kids unless there's clear and convincing evidence that this would be harmful to the kids, people talk as if somehow that's going to tie judges' hands and they'll never be able to protect children. That's just absolutely not true.
Yeah, let me add on to that, Don, because that's exactly right. If you find my testimony on YouTube when we were passing what became Act 604, I focused my testimony almost exclusively on the clear and convincing burden of proof. And some of the examples I gave were if we can't use it in this situation, why do we use it for punitive damages for corporations? Because they have to prove, to impose punitive damages against corporations in Arkansas, you have to show that by clear and convincing evidence. If you want to change the terms of a will in Arkansas, you have to do that by clear and convincing evidence. So there are other examples in the law where fundamental rights are protected and that burden is applied. And to say that it's not proper for custody cases is just nonsensical.
Awesome. Okay. Well, with that, let's switch over to Senate Bill 174. So the proponents and sponsors of the bill are marketing this bill as being child-centered, as putting kids first. That's the newest catchphrase they're attaching to it. That it actually gives more guidelines and more guardrails and accountability for courts. Now, those of us who've been really looking at this bill for the past few years, and so, I'm one of the people who had a copy of this, a few years ago. So this bill isn't new to me, but it's new to a lot of people. It seems to me like all those things are untrue. However, I'm not an attorney. I'm not an expert, and so I think it's valuable to get your opinions on some of the language of the bill, so that they don't have to take my word for it as a layperson. So I want to start with first, they're really emphasizing these quote unquote new policy statements, and I'll just recap that because they're not new, so I don't think we really need to even address them per se. But they are saying that it's establishing equality because there is a clause in there that says they can't prefer a parent based on gender. We already have language that exists in multiple places that does that. So they're claiming that's a new clause, but it's not. But they are saying because of that, because the language does say they can't prefer a parent because of their gender, that somehow establishes a presumption of equal parenting. So what are your thoughts on the language when it comes to the gender non-discrimination and its interpretation as an equal parenting presumption?
So I think every state but one, I've heard there's one state that doesn't, but I think every state but one has a prohibition on using gender as a factor in determining who will get custody of the children. That doesn't mean the courts don't do it. It means they're not supposed to do it, but there are, of course, unconscious biases that people are subject to and so forth. But the requirement that you not prefer one parent to the other based on gender doesn't do anything to promote equal shared parenting. It means that, if you flipped a coin to decide who was the sole custodian, you wouldn't be preferring one based on gender. It means, I guess, that the parents have equal chance, if the court really follows this, if they're not subject to this unconscious bias. It means that each parent has an equal chance of losing custody. That's not shared parenting. That's not a presumption of shared parenting. You're certainly right, Elizabeth, that there are a lot of things that are being billed as new in SB 174 that are not new. The promoting the best interest of the child standard has been in Ohio law for a very long time, as it is in many states. Not discriminating based on gender has been in Ohio law, as it is in many states. the policy statement in SB 174 looks like it is a significant change to some people. But we have to distinguish in talking about whether SB 174 is child focused or child based or puts the best interest of children first. We have to distinguish between the rhetoric and the substance, because the SB 174 says that the court will maximize the time the children have with each parent if it's in the best interest of the child. That means that there is first a determination about the best interest of the child, right? And then the court will award maximum parenting time to both parents if it finds that it's in the best interest of children. Well, of course, that does nothing new in Ohio law, because right now courts are required to make decisions based on the best interest of the child. If you added a clause that said courts will award custody to the parent whose first name begins with an earlier letter in the alphabet when it's in the best interest of the child, that doesn't change what they do. They're already supposed to be making judgments based on what's in the best interest of the child. So a presumption that, or a policy statement even, that, of course, policy statements don't have a legal effect. They are nudges to the court. They're encouragements to the court. They're not legally binding on the court. But a policy statement that at least had some substance would be a presumption about what's in children's best interest. It would say there are states that say it is the policy of this state to maximize the time the children have with both parents. That is a substantive policy statement. Something that says it's our policy statement to do something when we think it's in the best interest of the child just says do what's in the best interest of the child. It doesn't add anything new to Ohio law.
Yeah, Don's absolutely right. I can't recall the case off the top of my head, but the principle that mom or dad can't be favored in family law courts goes back to, I think, a facial challenge to a state that actually had in their code that the mother would be favored. And so it was an equal protection challenge, unconstitutional. And after that, nearly all states adopted code that said neither mom or dad gender would not be a factor in the decisions. And that's what we call a facial challenge to the code, or how the code reads on its face. That's not the issue. The issue is how the code is applied, and the results that are obtained or received when the code is applied, and is it truly neutral in that sense. And so I think that's the concern that we've been tackling over the years. And with regard to the maximizing parenting time, when I saw the notes from Ohio that's going to be the standard, that's the default in Arkansas for non-custodial parents, right? That's what we use when the presumption is rebutted. So maximizing parenting time for the best interest of the child, that's what all other parents get in Arkansas that don't get joint custody under our presumption. So the fact that Ohio is utilizing that as their starting point, to me, is quite troubling.
I will add some speculation here. It is hard for someone who's watched the legislative process unfold in Ohio to resist the conclusion that some of the groups in Ohio that you mentioned in general around the country oppose presumptions of equal shared parenting, the Bar Association, the Judges Association, and so forth, that some of them are looking at the handwriting on the wall. They're looking to Arkansas and Kentucky, and they see that shared parenting laws are passing, and they're very popular with the public, and they're trying to head this off so that Ohio doesn't pass a law that actually promotes children's interests substantively and not just with empty rhetoric.
Yeah, for sure. Now, this is me not being an attorney, so I actually have a question about specific language regarding the maximizing parenting time. And Brian, you tell me if these words are meaningful. Maybe they're not, so that's why I'm asking. But it says the purpose of the parenting plan is to allocate all parenting responsibilities to parents, and ensure that they share the responsibilities, enjoy a meaningful relationship. That's all actually current law. But this is where they add maximizing parenting time. But it says the plan shall seek to maximize parenting time. So is there a difference between the plan shall maximize parenting time or shall seek to maximize time?
Yeah, I think with all code there's nuance, and you have to look at every word, every minutia of detail, and certainly that is one that lawyers would fight about. Does it mandate maximizing time, or does the court have to just seek to do that? And uh, again, when you add words like that, you're giving the courts more discretion to decide cases, and the more discretion they have, the more power they have to decide the case how they want to, the more protection they have from getting reversed on appeal because they have that discretion. And that's all, you know, that's what the judges want. They want that power and protection to decide cases how they see fit. And that's really what a huge part of this fight is about. Because again, in Arkansas, our biggest fight was with the judges, and they wanted to maintain their power in these types of cases and not be told they had to start with a presumption. And you have to have legislators. Unfortunately, some states don't, but in Arkansas, we were privileged to have that, to go to war with the judges and say, we don't agree with you. We reject that concept, and we're going to do what's best for the children, what's best for the parents, not what's best for the judges. And really tell the judges to go pound sand.
Everyone would like a job where they don't have any constraints on them at all. And so it's natural for the judges not to want to have a presumption, because a presumption, as I said, they'll still have discretion. It doesn't prevent them from making an individualized judgment. It just requires that they start with at a certain starting point. But it's nice to have a job where you don't have to you can do whatever you want without any guidance at all. I don't think that's appropriate. That's not how we handle other areas of the law. We don't say that in criminal law, the judge shall have complete discretion to do whatever he or she wants to do. We say there are certain presumptions. There are rules that constrain the judge, and it's perfectly appropriate for there to be rules that constrain domestic relations judges in light of the evidence we have about the benefits of shared parenting for children.
So, Elizabeth, I just pulled up our code to more pointedly answer your question. So, if you look at Arkansas Code 9-13-101, subsection B3, this is for situations where the presumption is rebutted. And it says, when the presumption is rebutted, the court shall enter a written order that includes the following: facts, findings, and conclusions of law, and a parenting time schedule that maximizes the amount of time each parent has with the child and is consistent with the best interest of the child. So there's no seeking to do that in Arkansas. It shall be done.
Yeah.
Great. So along the conversation that we are having about discretion. So currently courts do have broad discretion. So in a legalese standpoint, what is broad discretion, which they currently have? Because on page 164 of Senate Bill 174, the bill allows courts to have complete discretion over the approval of a parenting plan. So is there a difference between broad discretion they currently have compared to this new complete discretion? And what are some of the concerns surrounding that language?
Well, if there wasn't a difference, they wouldn't have added the language. I mean, that's the short answer. There is a difference. And sure, family courts have always historically had broad discretion, but to say they have complete discretion, I mean, again, you run into, I think, areas of concern with due process, because certainly if if the parents agree, for example, and there's no clear and convincing evidence that there's a danger to the child, or the parents have entered into some agreement nefariously, the court should have absolutely zero discretion to reject that agreement. And to say that the court would have discretion to reject that agreement in that situation, to me, is preposterous and abhorrent.
So Brian is the attorney here, and I'll defer to him on this. But I think the standard of review for appeal is abuse of discretion on the part of the court. And I don't know what it would mean if I were an appellate judge and I were confronted with a case and the law said that the trial judge had complete discretion. I don't know what would constitute an abuse of discretion if you have complete discretion.
Yeah.
It seems to me that it's making the possibility. It's hard enough to appeal a family law case in court. I mean, it's a very difficult thing to do because appellate courts are probably appropriately deferential to the trial court because the trial court has actually heard the testimony and seen the demeanor of the parents and all of that. But this seems to me to make it an almost impossibly steep climb to appeal. And so the abuses of the violations of due process that Brian has just mentioned, I think they're not going to get remedied at the appellate court level either.
No, I agree with Don completely. The standard of review is already difficult enough in family court with abuse of discretion. And with this language, I could easily see a court saying, or a lawyer arguing, there's no basis to overrule the family court judge because the family court judge has complete discretion. So whatever ruling is made will never be reversed.
That would beg the question of, would a statute like this be considered an expansion of power?
Yeah.
Yeah.
I think absolutely. I mean, when you broaden a judge's discretion, I think I said this earlier, when you broaden a judge's discretion, you broaden their power to decide the case, and you also broaden their protection from being reversed on appeal. And those are two kind of concepts that are tied together because the more discretion a judge has to decide the case, the less room for error in being reversed on appeal. And so I think those work in tandem. And I think absolutely it gives the judges more power to decide cases and less opportunity to be reversed.
So Brian touched on this, but I want to emphasize it because it's a really important point. One of the ways in which SB 174 expands the discretion of judges is to, for the first time, to my knowledge, and maybe I don't know of any other state that does this, this bill would allow a court to override the joint decision of the parents about how to raise their children. So parents can come to the court and say, we've worked out this shared parenting plan that we think is in the best interest of our child. And the court could say, no, you can't do that without the court first finding that the parent's plan would be harmful to the child. And that is an extraordinary expansion of the court's authority, the court's power over families. And I frankly think it's unconstitutional because the Constitution, as interpreted by the Supreme Court for over 100 years, says that the state cannot interfere with how parents are raising their children unless they show there's harm to the child. The state is not supposed to be a substitute parent or a supervisory parent there. It's not supposed to substitute its judgment about what's in the best interest of the child for the parents. It's only supposed to protect the children from harm.
I agree completely, Don. In Arkansas, we built in language for parents that agree to, if they want to deviate from joint custody and rebut the presumption, we have that language and the courts have to honor it. And unless there's some finding of harm to the child, or like I said, some nefarious agreement by the parents that will harm the child, absent evidence of that, the court, I think, constitutionally has to honor the agreement of the parents. And to do otherwise, I think, is extremely problematic, and I could absolutely see a constitutional challenge arise.
Now, the proponents will say that they have to do that because the courts need to retain the ability to override parents' judgment if it's bad for the child. So can you just clarify the difference between intervening to protect a child and just completely overruling fit parents? Like,
Well, the problem with that question, Elizabeth, is the fundamental premise that the state knows better than the parents what to do with the child. That's that's the fundamental problem with all of this, is that some believe that the state knows better than the parents, two fit parents, what to do with their own child. And when you have two fit parents who make an agreement as to what should happen with their child, I don't think the state has any role in changing that. And it's complete hubris for those who think otherwise, to think that the state should have a role in deciding what should happen to that child when the two fit parents have agreed, and that agreement absolutely is consistent with the law.
Here's a question I think to pose to those who think really that the judge or magistrate in Ohio knows best for what's for children. How many cases do they have? How many cases are they sitting over? Um, how well do they know those kids, those parents, their family situation? And the answer is they can't know very much about it, really. Um, so the idea that they, of course, the state has an interest in protecting children, setting a threshold. You know, if parents are doing something that's harmful to the children, that's a different matter. But to be able to substitute the judge's own decision about the best way to raise a child for the parents when without any showing of harm, that's what's really problematic here. And in Ohio, it is surprising that there are people that early there are senators, Ohio senators, that early in 2025 voted for a parents' rights bill that says that parents have the right to control the education of their children, the medical treatment of their children. And then in November of 2025, I think 17 of those same senators voted for this bill, SB 174, that says, but they don't have the right to determine how their children will be raised if the parents are living apart. Then the state can jump in and decide how it's going to happen.
Yeah, Don, I mean, you hit the nail on the head. Judges, um, lawyers, attorneys ad litem, they rarely see the children after the case is over.
Right.
Beyond the attorney ad litem, maybe meeting with them a few sessions, the judges sometimes never meet the children. The lawyers sometimes never meet the children.
Yeah.
And for them just to again, it's hubris for them to think that they know best, that they can decide what's best when parents do agree. To me, is shocking.
now, one of the things the sponsors did is they did amend the bill last minute before it was pushed out of committee to include findings of fact. And I'm going to read that language to you. It's on page. Okay, I'm sorry. It's on, yeah, page 163. So basically, they lay up that if parents come in with a joint agreement, the court can overrule it. If one parent files a plan, the other one doesn't, the court still can pick, or they can reject both plans. But what they've done to try and make us feel better is they added language to provide written findings of fact. So I'm going to read it to you, Brian. If you could help me understand this language and what it means. So it says, if the court finds that the joint parenting plan is not in the best interest of the child, the court shall provide written findings of fact to support its finding.
Yeah, I mean, so first, anytime you get a proposed change from the judges, I take that with a grain of salt because, in my experience, that proposed language is going to benefit the judges, not the parties, not the children. So I would be uh, not exactly trusting of whatever language is proposed. Secondly, that language is a little watered down from what Arkansas and other states have adopted. I'll read you what Arkansas adopted again in 9-131 B3A. the court shall enter a written order that includes facts, findings, and conclusions of law concerning the basis for the court's determination. And that's in the case where they deviate from the presumption. And the reason that you have facts, findings, and conclusions of law is those are distinct concepts in the law. You have facts, which are evidence put forward by the parties into the record, and the judge can summarize those facts. Findings are factual findings that the court or the fact finder can make from the evidence. So, for example, if you have a car wreck case and the jury is faced with answering the question of negligence, or whether a party was negligent, that's a fact finding question that the jury is going to make, and the judge makes those factual findings in family law cases. And then conclusions of law are interpretations of the law, applying the law to the facts and the factual findings to make that legal conclusion. So those are three separate distinctions in the law, and that's why Arkansas and other states have specifically enumerated those three categories to be required in the written orders. Why? Because if you have all of that in the written order, it makes it easier for the party who loses to appeal to have that record. It's a more developed record, it's a more precise record, and it's easier to appeal from that order. Having a more watered down or nebulous definition like you just read makes it more difficult to appeal, and again protects the judge making the decision.
One of the problems that I have with this language about requiring written findings, and I learned a lot just a minute ago from Brian talking about this from a lawyer's point of view, but it's really unclear what level of specificity is required. I mean, if a court can say, I find that equal parenting time isn't in the best interest of children because the parents don't agree to equal parenting time, is that sufficient? They've given their reason for it. So what some statutes say is in specificity that the reasons that the court finds that this inappropriate. I think the language could be much stronger than this. It just says provides written findings, and there's no guidance at all at what level of detail these have to be.
Right. And then going back to what we were talking about a minute ago when it comes to discretion, how helpful would this language be anyway if the courts have complete discretion?
Yeah, I mean, you've got a Pandora's box of problems that this bill opens up with, combining complete discretion, combining this watered down version of findings. Again, all of that is to the judge's benefit. It's not to the benefit of the parties. It's not to the benefit of the children. And if you want to do it right, if Ohio wants to do it right, they would look to Arkansas, Kentucky, West Virginia, Missouri, some of the other states that have actually adopted very good code on this point, to direct the judges to make very specific findings and create a good record for the parties to appeal these issues if necessary.
If those pushing SB174 really cared about changing Ohio law in a way that would benefit children, they would take a look at the other states, as Brian was just saying. They'd take a look at the results in Kentucky and Arkansas and West Virginia and Florida and Missouri and in Arizona, that doesn't have a presumption of an explicit presumption of equal shared parenting, but they have a strong shared parenting law. And what they'd find is that children do better. There are lower rates of intimate partner violence. We haven't talked much about the intimate partner violence, except to point out that every statute has an exception for that. But we now have evidence that presumptions of equal shared parenting decrease not only child maltreatment, but also intimate partner violence rather dramatically, actually. They'd look at the evidence from these states and follow those states. So we have Ohio lawmakers don't have to be the icebreaker here. They don't have to be the first state to go out and let's do something different. They can look at the success in the states that we've just talked about here, and they can follow that success instead of doing something which is really largely putting lipstick on a pig.
There are people who say, well, can't we just amend this bill? Can't we just cross out? What if we crossed out complete discretion? And my answer has been, well, the problem is all of the whole premise of the entire bill, but also there are plenty of um, parts of the bill that consistently give courts unlimited authority. For instance, when it comes to the best interest of the child factors, they did expand the factors. They gave the court more things to consider, but they also gave any other factor the court wants to consider. And then in the parenting plans, they give a long list of things that parents have to include in these parenting plans now, and any other provision that the courts want to include in a parenting plan. So it seems like in every section of the bill, there's a catch-all. And so I don't know how you could amend that out.
So can you amend SB 174? There's a question of what counts as an amendment and what counts as a complete substitution. I suppose you could delete enough things and add enough things to make it a good bill, but it would be a dramatically different bill. I don't think it would. It could be an amended version of this bill in name only. Of course, this is more evidence that this is a product of the judges, because it's very nice to have a catch-all and any other thing you think is appropriate thrown in at the end. You're not limited to looking at certain factors there. But to directly answer your question, Elizabeth, I think an amendment to this bill that would make it really in the best interest of Ohio children would really be a quite different bill.
Yeah, I agree, Elizabeth and Don. Ohio had a really good bill in the past couple of years, and SB 174 is not that. 174 is a bill written by the judges to protect the judges, enable the judges, and it really does nothing for the parties or the children involved in these cases. And I think it will actually do more harm because it will create more conflict and more fighting because of the ambiguity. So this issue I've said before is really a civil rights issue of our time, and it's a parental rights, it's children's rights, and SB 174 is on the wrong side of that issue. And I hope Ohio will change course and join other states like Kentucky, Arkansas, West Virginia, Missouri, Florida, and get on the right side of the issue.
Everyone is attacking me for saying this is an expansion of power. Like they are so mad at me for saying that.
SB 174 is an expansion of power because it expands the judicial discretion, it expands the role of judges, and really jeopardizes, I think, the parties and the children's in family law disputes in Ohio. So I think Elizabeth McNeese is exactly right on that point.
I'm thinking here because
Yeah, think
there are
away, think
different
away.
things I might want to
And you
focus
guys
on.
can add anything else too. I just don't
Yeah,
want to keep you if
yeah.
you have somewhere to be.
As someone who's researched and written and published on constitutional issues concerning family law, I believe that SB 174 is unconstitutional because it allows the state to substitute, through its courts, to substitute its judgment about the best interest of children for the judgment, the joint judgment of fit parents without any showing that those parents would be doing something harmful to their children. It is not going to do anything to decrease parental conflict. What it is going to do is to increase it because it makes it very unclear what the outcome of custody decisions will be. There's no assurance to parents that they'll continue to have a full relationship with their children after divorce. And without those assurances, we're going to see parents fight harder and longer battles to try to stay involved in their children's lives. And that's going to impoverish parents.
I think one thing that, in addition to the statistics we've seen in Arkansas, is some of the case law we've seen decided in Arkansas. We've seen the appellate courts really embrace Act 604. And sorry, my dogs are barking. I'll try to start over. In addition to the statistics we've seen in Arkansas, we've seen the case law, and some of the appellate courts really embrace Act 604, and it's really been good to read some of the opinions the past couple of years directing the lower courts to embrace joint custody, that joint custody is the law of the land in Arkansas, and see that in written appellate decisions. And that's been a positive development. Then we're hopeful to see more of that.